Good afternoon, and welcome to another session of Ask Judge Carol. And today we are continuing the series on probate, and I'm going to talk about what happens when there is no will. So last week I would have given an outline on the steps that you take when you're going to make an application for probate. I mainly dealt with the process that you undergo when someone dies with a will, and you have to make a grant, and the executor has to apply. So once again, it's important to remember that once someone dies, in order for you to be able to handle their property and deal with their property, the court needs to make a grant, and it's either a grant of probate or it's a grant of administration, letters of administration. But either way, one of the things that I often say is that the property doesn't transfer by heir. So I have an example that I'm going to share this afternoon where someone has written in with a question, and I'm going to go through that and break down why it is important for you to make the application for a grant, why you have to go to court and have the property transferred. So we're talking today about when a loved one dies without a will. And the moral of the story, if I can say, or the theme for the story today, is that if you don't deal with it, then the court is going to decide for you if you don't have a will. And even in the case of inheritance, we're going to see that the law sets out what are the degrees of inheritance for people to inherit from you. So dying without a valid will, or in the case where there's a will but it doesn't actually dispose of everything, is what the law calls an intestacy. So a testator is the person who makes a will. Then when they're deceased, they're called a testator. And if a person dies without a will, then they're called, and the term is intestacy, and the rights of persons to inherit from them is under the Inheritance Act. So the legal framework in the Bahamas is that the Inheritance Act says who are the people who are entitled to inherit from your estate. And since we're talking about intestacy and letters of administration today, I'm going to briefly run through that with you. So with regard to the act says, with regard to the real and personal estate, their property goes, first of all, if they leave a husband or wife, they go to the spouse. And then if there are children, then it's shared between the spouse and the children. And if there's no spouse and only children, then the children share in the estate. And the law basically goes down degrees of the closeness of the relationship. So then if there's children, but no spouse, it's distributed equally. And if no spouse and no children, then it goes to grandchildren and so on. So if you are in a situation where you're not sure, there wasn't a will, and you're not sure where you fall in line, that is a good opportunity for you to consult with your lawyer to find out where you fall in line. And the reason that you need to do this is because depending on where you fall in the line, and the law goes way down, in terms of degrees of relationship, depending on where you fall in the line, that determines who gets to apply for the grant of administration. And of course, the person who applies for the grant of administration is the person with the power over the estate. They're the one that calls the shots. And so if you have other siblings, other relatives, and you want to secure your interest, then you need to go to court and get the papers, the grant of administration, in order for you to be able to deal with the estate, because the administrator then stands in the shoes of the deceased. Basically, that means that they have the power to deal with the property of the deceased, the real property, and the personal property. And in the case of real property, you have to, the the chain works like this. So someone dies and they didn't have a will, so a family member, the spouse or the child, applies to the court for a grant of letters of administration. They owned property in a particular location. In order for that person, the personal representative or other beneficiaries, to actually inherit, not just to be entitled to, but inherit it, meaning get papers for themselves, then the administrator, when they would have received the grant of probate, they prepare a deed from themselves as the personal representative or administrator to the beneficiary, and the beneficiary then takes the title to the property in that way. And when I say beneficiary, I'm talking about the persons who are entitled to a distribution of that intestate's estate. So you need to have that paperwork happen, that transfer of title has to take place in order for you or other family members and relatives to inherit. So I'm going to say that again, just because I want you to get the distinction between being a beneficiary, right? So my mother, my brother, my sister, you're a beneficiary of their estate on an intestacy because of your blood relationship, but you don't actually inherit it until a deed is prepared by the administrator. And really, we're talking about in cases of land, because for personal property, the administrator simply has to hand it over to you. If it's a car and they're handing over keys, or if it's a set of china or fishing equipment or a sewing machine, then they physically give you the property and you have possession of it. So there is no deed that is required in that instance. So again, just a brief recap of the order of priority. You have the surviving spouse, then there comes children, and then if no children, then grandchildren. And that is the order in which you, if you fall into one of those categories, are entitled. The court will recognize you as having the right to apply for the grant of administration. So that's why, and so as I say, that gives you quite a bit of power if you are the person who gets the grant of administration. And if you are concerned that maybe there is a will and you're not sure if there is, or you don't know who the executor is, or in the case of family members, you want to ensure to preserve your interest, then you should file something called a caveat in the court to prevent a grant of probate or letters of administration being issued by the court and you are unaware. So the reasons for filing a caveat are if you are concerned about the validity of a will, or concerned about an executor's entitlement to apply for a grant, or that there is some concern about the improper distribution of assets, then you will want to file a caveat in the court. So it's very important that you deal with the estate. You can't do anything before 14 days has passed from the date of death of the deceased, but thereafter you can make an application, or in the reverse situation, you would file, a caveat, and your lawyer will guide you on the process, which documents to produce, to file, and the filing process within the court. Now, when I talk about let me just say, when I'm talking about making an application, filing documents, applying for a grant, and so on, there are specific procedures outlined in the rules of the court, and the applications are filed at the Supreme Court registry. In the case of the probate division, or the probate side, the office is located on Bernard Road. It used to be located in the Ansbacher House Annex of the Supreme Court downtown on Shirley Street and Bank Lane, but the whole family division and related sections of the Supreme Court are located on Bernard Road in the family complex, and that's where the probate registry is located. So if you were going to do a search, or someone was going to have to go and do a search to find out about an estate, that's where they would go. You may or may not, for example, if you had to get a birth certificate, death certificate, those kinds of documents, they are filed at the Registrar General's Department, which is on Shirley Street, now located on the northern side of Shirley Street in the Bahamas Financial Center. But the Supreme Court, so that's where you are going to go. Supreme Court Registry is the office, the court office that deals with applications for grants of probate and administration. And so you would want to, it's good for you to know that and to understand that. You know, if you're applying for a passport, you're going to go to the passport office. They're located on University Drive, formerly Thompson Boulevard. Registrar General's office, I've just told you where that is. Supreme Court Registry for the Family Division is located on Bernard Road. And so the court deals with reviewing the applications. There are registrars, or probably is a particular registrar who's responsible for reviewing the applications as they are submitted. And as I had mentioned on the last occasion, the process is scrutinized carefully and closely by the court to make sure that the person who is entitled, or the persons, because it could be more than one, who are entitled to receive the grant of letters of administration are in fact the ones who receive the grant from the court. So make the application. I would encourage you, if you have a relative that has passed, to make the application as soon as possible. Within a couple of months, you should go and see a lawyer, and there are a number of documents and things that you would have to pull together for that. And so the process can take some time. And then, because it's a scrutinizing process as well with the court, that also takes time. People say, well, how long does it take? It can take a few months, anywhere, I would say, from probably 3 months to 9 months, provided you have all of your documents in order to get a grant of letters of administration. And then, as I say, once you have that, then the process of transferring the title deeds from one person's name, from the name of the deceased person, into the name of the beneficiaries, that's another process in itself. So you want to allow time for that. So I've just really skimmed the surface. I would encourage you to consult a lawyer, because different scenarios and different permutations of situations happen that you would want to get guidance for your particular situation. But in the few minutes that I have remaining, I'm going to review a scenario a question actually that was submitted, and discuss how the probate procedures apply, or would have applied in this case, as an example to help you to understand and grasp the concepts. So here's a question submitted by Vernice. That's actually not her real name, but I'm going to use it for this example. Vernice says, my mother was married to a man who was not my father. So then her stepfather. Her mother died in 2017. And before her passing, she willed her 50% interest of the home to me. Then she continues, my stepfather died 4 years after her. So that would be, say, 2021. My stepfather had not written out a will, but verbally told me that the house was mine. I lived in the house from 2002. Both had given me permission while still alive to build on the premises. 4 months after my stepfather's death, his son gave me an eviction notice claiming that he was the rightful owner, and I was summoned to civil court on the basis that I owed him 5 months' rent. When we got to court, the magistrate ruled in his favor, and I was evicted immediately after living in the house for 15 plus years. How could that happen? Is essentially what the question is. She gave me the scenario. She didn't have a specific question, but obviously she wants to know, how could it be that if she had lived in the house from 2002 and her mother willed her 50% share and the father gave her permission to live and to build, how is it that the magistrate was able to make an order for her eviction for being in arrears of rent? Now, so let's break this down a little bit. So from this case, we see, first of all, if the mother had made a will, it doesn't appear that anyone ever proved it in court. So no will was produced and no probate was granted in the mother's estate. So everyone just carried on about their business. The stepfather lived in the home, and the stepdaughter continued to be able to live there, and at some point she built on the premises. So to Vernice, I would say, and to any of you, if once someone has passed, if your relative, your mother, father has passed, and if you think there was a will, you need to see about getting it probated. Take it to court and get it probated. And it doesn't appear that one was ever discovered either. So the property basically has been treated as having been passed on an intestacy. And the stepfather passed, and then what happens? Well, that's not her father. And the son apparently inherited. So the stepfather, then it becomes his home, wholly and solely, and his son inherited the house from him. So that's basically what happened, with no probate and no letters of administration being taken out in the mother's estate. Basically, it would seem that she has lost her interest, and the court would have treated her as not actually having had an interest because her mother's estate was never probated. So the house was treated as belonging to the stepfather. And we're now in 2026. So the stepfather died in 2021, and we are now in 2026. And as far as the court would have been concerned, based on the evidence that was before it, the son inherited the house from the father. The only evidence we have regarding the daughter's residence is that she had permission, verbal permission from her mother and then later her stepfather to live in the house. And the son is not legally obliged to recognize what the law sees as a personal favor to you as the daughter to live in the home. So there's been no mention in this question that was submitted to me of any documentation, of any paperwork. It's just, I live there with my mother. My stepfather said I could live there. He said I could build on it. But from the eyes of the law, that's a permission that was granted personally as between you and the stepfather, and with nothing in writing and no probate from the mother's estate. then the father would have been entitled to uh, her as her spouse to inherit from her estate. Now, you would have had an interest, this is to the daughter, you would have had an interest and would still potentially have an interest in your mother's estate. But the only way for you to be able to receive that is what I've been talking about on this session today, which is for you to make an application for, and you're going to have to now go back to 2020, 2017, sorry, when your mother died, and get a grant of letters of administration into her estate. And that, would imagine, would be a very complicated process and a can of worms to go back. We're actually talking about 10 years. It is possible, but certainly you are going to have to instruct a lawyer and see if there's any interest left in that home for you to be able to inherit. So if you want to inherit from your loved one's estate, then them telling you and promising you this is for you and so on isn't going to cut it. You need to make the application to the court. So I hope that today's session has been helpful for you. I will be back again next week with another session. I haven't confirmed the topic yet. I'm going to see what questions come in, and then I will make a determination for what next week's topic is going to be. In the meantime, if you have a burning question that is troubling you, you can apply for a 20-minute one-on-one session with me. Send a request to my WhatsApp number, 451-4855. That's 451-4855. Or submit your form at judgecarol.net. That's apply via my website at www.judgecarol.net. And don't let the law write your will for you. You be sure to make your own. I will see you next week, same time, same place. Have a good afternoon. Thank you for tuning in. This is Judge Carol. Send me your questions at 451-4855 or book a session one-on-one and have those burning, troubling questions that you have on your chest, and let me bring clarity and peace and less stress in your life.